for this first Thursday of of February the 1st, 2004. Their agenda begins with a few administrative matters. The first is the approval of the minutes from January 4th, 2024. Are there any corrections, changes, adjustments?
Move they be approved. Second.
All those in favor, please say aye.
Abstain.
Thank you.
So Don Coates abstained.
So we'll immediately go into the old business, which is, Kevin, would you like to present what we're doing? This is the
You can do
review.
election of officers.
Oh, yes, I'm sorry.
Okay,
Relinquish
Move.
the
what
chair.
happens is this goes to you.
Relinquish the chair to Elizabeth, I think.
Yeah, right.
I think that's me.
I'm sorry.
And call for nominations for the chair of the Planning Commission.
Lois Kelly.
Oh.
Are there any further nominations? Hearing none, I call for a vote.
Aye.
Ms. Kissinger Kelly is voted as chair of the Planning Commission for 2024. Congratulations.
Thank you very much. And I would like to nominate the vice chair, Peter Schleyer.
Second.
All those in favor?
Aye.
Very good.
They go fast.
I'd just like to say one thing about the volunteer planning commissioners seated here with me. They bring such a wealth of knowledge from a wide range of professions. We have an attorney, a journalist, sports writer, a certified public accountant, and an executive business manager who actually held the position of Bel Air town mayor several years ago. I'm very pleased to sit among these highly qualified volunteer planning commissioners who take most seriously their commitment to the betterment of you and our town. So we
That was the acceptance speech?
Oh, exactly. And thank you very much. So the first, we're going to go back to old business, legislation that had been tabled from January to give everyone an opportunity to review the ordinances.
Correct. And as far as, and I'll defer to the Planning Commission here, the first ordinance, which is a revised ordinance, will have public comment. The other three is up to you whether or not you want to continue public comment. Since you got that last time, it's up to you. So what I'll do is I'll give a short little summary and then turn it over to Commissioner Rutledge. Is that all right?
Yes, thank you.
Okay, the amendment, as it's currently written, proposes to reduce school capacity threshold from 110 to 100 and to eliminate from consideration the capacities of abutting attendance areas for school APF. The intent of the regulation is to prevent residential projects from obtaining actionable planning commission approval. And I do stress actionable. You can approve projects. They just can't proceed to get a building permit. They just go into a queue. That's the way it works for this part of the code. And that slows development in areas where schools are over capacity or projected to be over capacity within the next 3 years. The current code allows for abutting districts to be assessed to encourage the adjustment of school attendance areas by the Board of Education, which never works, and when capacity exists within those nearby schools. And with that, turn it over to Commissioner Rutledge to propose his revisions.
Okay, good. Well, first of all,
Name
Honorable
and address, please.
Jim
Oh,
Rutledge,
okay.
and I reside at 214 Wellington Court in Bel Air.
Okay,
And
thank you.
Madam Chair and members of the esteemed Planning Commission, first of all, thank you very much for serving the people of Bel Air. Thank you very much for giving me the opportunity to come and share with you this evening and a concept of a proposed amendment, well, a concept for a bill regarding the school capacity, otherwise known as APF. What you have had before you was a received resolution, a received bill to consider, as Director Small stated, reducing the capacity limit from 110% to 100%. that is really the heart of the resolution or the proposed ordinance that was received and then that you have had under some consideration. It was tabled. While it was tabled and before that bill expired, I took initiative to, I've been studying the issue pretty carefully over the last couple of months, and took into great consideration. We had a number of hearings. We didn't have just, we had one official public hearing, but we as town commissioners had more than one opportunity, and people did come forward and speak for and against that proposed change for the school adequate public facilities rule. As I reflected on what I heard in my capacity then as a sworn member of the Board of Commissioners, I then undertook to explore to put forth a bill that would only remove the words abutting, so that any project was considered based on the merits of the neighborhood in which it was being built, and not reduce the number of 100% to 110% to 100. So my proposal will not change the 110% rule. The 100% rule, although if I could go back in time, if I had the ability to help the people of Bel Air and the parents that go to schools be able to have a system that was built better so that there could be more adjustments in school lines to take advantage of all the tremendous investments in schools that we have in this county that are under capacity. If I could do that, I would, but I can't. And even though I wish that were the case, that we could provide some more immediate relief to our children, especially in Bel Air Elementary School, as well as at Homestead Wakefield, that would be wonderful. However, the county has a 110% rule, and becoming inconsistent with the county struck me as something that I think warrants a tremendous amount more, perhaps, coordination or conversation with the county as a whole. Whatever can be done, and I know it can be a frustrating process for many, what can be done to work with the Board of Education to persuade them to make some changes. All of that I took into account and took a look at, well, you know, for many, many years there was no exception for abutting in the language of it. And in fairness, I feel like it is a good, solid piece of public policy to promote the 110%, but delete the abutting language. In the same context, though, I also considered testimony and statements and information, you know, that were presented to us from those landowners and property owners that had put forth a tremendous investment as they moved projects forward in this town, certainly long before any kind of election year, long before any changes in the composition of the commission, and had invested a tremendous amount of money and resources. And this commission has invested a tremendous amount of time and effort in considering projects that came before it. The Board of Appeals put in a tremendous amount of time, energy, and expertise in considering projects that came before it. So it strikes me that even though I don't think it's legally required to take those commitments, efforts, investments into account necessarily from a legal technical standpoint in the way that our zoning regulatory laws exist now in Maryland under our current rulings of our high court, I think as a matter of public policy and basic fairness that the change of the erasure of abutting would not apply to a certain class of projects that are in the pipeline. And so I worked up some concepts. I consulted with Director Small, consulted with council as to the verbiage to make sure that my purpose was matching up with the language and the technical terms in the code. And what I'm proposing is, yes, take out abutting, but this law change, if received by the Town Board of Commissioners, if then passed and adopted, I have, as you have before you in the record, that a zone, just a simple criteria, that any zoning case for site plan, subdivision plan, variance or special exception that has been submitted to the Department of Planning and Community Development prior to December 31 of 2023. Okay, that's one of the criteria to be exempt, but a proposal would have to meet all of these 5 criteria. Criteria 1, they put it in before December 31, 2023. 2, there was a minimum of at least 1 public hearing held prior to the end of 23 regarding that matter. Whether it would be before you or the Board of Appeals, any public hearing would satisfy that criteria. So to me, that means that they have put forth a tremendous amount of reliance on the existing procedure and law and investment to go through that hearing. Number 3 criteria would be that they would have to be keeping the project moving to where the approval, well, first of all, they couldn't have already expired. So the approval or granting of an application would have to be one that has not already expired under the code. So we're not like pulling something or resurrecting something that had already expired.
Do we have any examples of that? I'm trying to think of what we would have that could have been that.
I'm not aware of any, but it was suggested to me that that's a good safety guard and makes sense. So in other words, so long as the project hasn't expired, it's still, it makes
Yeah,
criteria
something that
1,
we
criteria
approved 2 or
2.
3 years ago and nothing.
Yeah, if it hasn't expired, and the 4 would be, did I answer that question?
Yes, you did.
Sir,
Mhm.
thank you. Then 4 would be that the final site development plan or approval in that matter would have to be granted by July 31 of 2024. That the project is moving forward to that point, and then the last criteria would be that they would then pull a building permit no later than November 15th of 2024. So in consultation with the Director Small, that's a doable time frame. It's not an unreasonable burden on somebody who's already been through their at least 1 hearing on their matter in 2023. So I think that's a good, fair measure. And that way, it gives those projects certainly the opportunity to proceed and not be shut down because the abutting language was removed. So in a nutshell, as many things are with legislation, I'm sure, my basic view is to try to achieve something, meaningful and substantive for the citizens of Bel Air and those families that depend upon our public school system for their elementary school children to be educated, but at the same time, not departing from the 110% standard, which is consistent with what the county is doing right now, and finally is giving due consideration and at least a fair consideration in my mind of the fact that many people may have relied to their detriment on existing laws to expend a tremendous amount of resource and investment in, and I think that this is an appropriate balance. And I hope to get your input, advice, counsel on the bill. like I said, I haven't introduced it, so it hasn't been received. I don't know whether I would get the votes for it to be received. And if received, I don't know whether I would get the votes for the bill to be passed. But I would certainly greatly value the support of the Planning Commission in my efforts to move forward with, I think, is a good, fair, and responsible piece of legislation.
I've got a quick question.
Yes.
The apartment complex across the street was approved last January or February. It's been a year. Theoretically, they have until next January before it expires. But if they don't pull a building permit before November, based on this, they would not be able to build,
That is correct.
Yep.
even though it hasn't expired.
That is correct.
Trust me, it doesn't hurt me because I don't like the project. But at the same
No,
time-
no, but
I just want to clarify that the way that it was structured is that as long as it hadn't expired, it was good, but then we read at the end of this that they have until the 24th of this year to pull a building permit. They may not be ready, yet they haven't expired, so.
November for the building.
Yeah,
permit.
so,
July for the
so Mr.
approval.
Coates, what I was,
so they-
as far as the not expired, what that clause is just making sure that generally speaking, if a project had already expired,
I understand.
none of the projects have expired that would be eligible for the temporary exception. So,
One thing to-
yeah,
One thing to remember here is the project is still good. What this legislation does, or the carve-out that Commissioner Rutledge is talking about, that portion of that code would then become effective regarding on November 15th if a project does not have building permit. So if a
Yeah.
project changes, if it does something different and it no longer needs to have, that's the kind of stuff that I just want to make sure that it's not telling the project, oh yeah, you're going to die on this date. It's just that the changes in the code will now apply to you.
But the changes in the code will affect the project.
It
and
will,
therefore the
in this
project-
case, yeah,
and
it's-
therefore
in the
project
case you're
dies.
talking about, yeah.
So,
So
Or-
something
or-
that-
the
something-
So what
project
would-
may or may not die. I'm not sure, what we'll be looking at there, but I get your point.
I mean,
Yeah,
as
so-
much,
so-
as
so-
much as I don't like what, more specifically, I didn't like the colors of it and the way it was designed, but beside that point, the mere fact that they can do what they want to do with that property, I don't know that, the fact that they don't have a building permit, or they've come up with something that they want to do and they want to run out the clock because of interest rates, the election, whatever. I don't know that we should cut them off at the legs by November 15th if they haven't requested a building permit.
So under the code, there's two provisions that kind of come into play here. So if they're moving forward and they've gotten all their approvals, but they haven't pulled their building permit by the deadline set forth in Commissioner Rutledge's proposal, they will sort of go into that conditional approval category in the queue. And then what will happen is the time on their approval will sort of suspend. So if they have 6 months left under their 2-year approval, the code provides, like, if there's any superseding legislation or there's a lawsuit filed and everything kind of stops, they are still given that remainder 6 months, but it doesn't start ticking in his case until that servicing school gets below the 110 adequacy, state rated capacity. Does that kind of help a little bit, sort of visualize it?
Yeah, I understand what you're saying. I'm just saying.
Yeah.
The way I read this is that they can sit on it all summer long, but by November 15th, they need to have a building permit.
Yes. Yes.
Yeah, so what I'm doing here, what I'm proposing is, they are being given something that the Supreme Court of Maryland does not give them. The Supreme Court of Maryland has no zoning estoppel law. They follow what's called the vesting on the building permit. So what happens is, as we know from the landfill case, even in Hartford County, that all kinds of radical changes to a zoning law can happen to a developer, and if they haven't pulled the building permit and started turning dirt on the project, they're toast. This gives say, that project the opportunity to move along and finish that. If they don't pull the building permit by November 15th, then the law applies to them, and the law that applies to them says that 1-year extensions of an approval plan may be requested without limitation. So they stay in the queue on that. So a couple of the things, and
That's
But
subject to
it- but it
approval of
would
the planning
follow-
commission.
But it would also follow the 110%.
What-
Who approves those 1-year extensions? The planning
Well, they-
commission,
yeah,
the
they come back
staff,
to
or
us.
whoever?
Planning Commission
Yeah,
does.
they come back to us and ask for an extension.
So does that date apply also to? Does that date apply also to Harvard Mall and Standard on Bond?
it would.
Yep.
It would, see, that,
Again,
because
that's at
those,
November the
I
15th.
think, but see, both of those projects applied, both of them had public hearings within 2023. And then as long as they got final approval by the end of July and pulled a building permit by November 15th. Now, Hartford Mall, under my proposal, is unaffected because they're not subject to the APF. At 110, they can build. But
Right, they're,
Different school.
yeah, they're a different school, so they, they, they would not be in the mix whatsoever. But let's say they were in a school district that was over 110% capacity, then to be exempt from this change of the abutting rule, if they were relying on the abutting county school having less capacity, yeah, they would have to move the project along and the exemption would sunset. So the concept that I came up with was give them an opportunity, give these, whoever meets this criteria, their opportunity to move forward, but not forever. Have some kind of end date on their exclusion.
First thing, I commend the move from 100 to 110. It never made sense to me for the town to be more restrictive than the county right on our doorstep. The July 31 concerned me, and maybe a little less so now if I'm understanding this reapplication of those specific projects, because it's now February the 1st. July 31st seems pretty quick even for any of those three to get whatever approvals that they might need from us. We don't always move, things take time, and we don't always move the fastest. It took us 3 meetings to approve a Taco Bell rebuild, so we like to be deliberative. But if I understand it correctly, if you don't meet the July 31st date, you can apply for an extension?
no, this July 31st, the way I'm reading, and you can correct me, Liz, if I'm wrong, but the July 31st, you don't have a final plan, you're done,
That's my understanding and reading
Don't have a
of
final
Commissioner
plan
Rudgley's.
submitted or approved?
approved.
Approved.
Yeah, that just seems tight to me, just given how I've seen things move along the way here.
It just depends. I mean, I think some developers come in and they move at a more deliberative rate, and they go faster, and some don't.
But we're carving out an opportunity for 3 specific projects that have invested lots of money, and then we're gonna say, well, you've now got just a few months to get approved, which the approval would be something they don't necessarily control. We do.
Yeah,
But for the final plan to be approved, it just needs to follow the requirements of the Planning Commission's conditions. And it needs to have a lot of times what we'll do is if you go in and there's a change, let's say they run out of money and they want to change something, you can get a final plan approved as long as it meets the Planning Commission's conditions. And then you can go back and revise that final plan if there are some kind of a change that you need to do. Sometimes it comes back to you for approval, but for the most part, the final plan is just making sure that they meet your requirements. So the plan that they submitted, that you reviewed, and you said, okay, we want to add X number of trees, we want to move the trash dumpster to over here, it becomes relatively a drafting exercise. Now, there are some things, like Taco Bell, where the architecture becomes an issue. And at that point, they need to decide.
And that's what concerns me about any of the projects, any of the three carve-out projects being held hostage by our deliberations. So I don't oppose the concept, but the timing seems a little tight to me.
Well, they're not necessarily held by our thing. I mean, we approved Liquid Flats across the street
But if-
last year,
but if-
and they, and we told them what we wanted, so.
They're in a different category because they've been approved,
Right.
at least at this level, but the other, the Bond Street has not. We haven't seen it yet. Don't know what hurdles that particular project has in its way to be submitted to us or when that's likely to happen. And there again, let's say if that project is submitted in a timely fashion by May or June, and now we do what we do. Now it's out of the control of the applicant, and here we are taking our time, which we are prone to do at times.
Something to consider is kind of what happens in Harford Mall. I'm just throwing this out there. If you guys had 2 hearings on that, so that was 2 months, and then afterwards you tabled the decision, so then Kevin and I could produce an opinion for you. That takes time, and then you guys have to vote on that opinion. So Harford Mall really was like 3 months. I'm just kind of throwing that out there along with what Phil was saying about the timing.
The other piece to consider in the carve-outs, and I like the idea of the carve-outs. I like the idea of the 110. I'll mention the abutting in a minute, but there is another unheard affected party out there somewhere that is currently zoned R2 and they've invested in the property. They've bought it. They haven't invested in lots of plans about what to do with it, but they have it, and then this particular piece of legislation would, in theory, diminish the value of their investment that they made by purchasing the property. Which, a way around that I might suggest for everybody involved, and tying into the schools, have this piece of legislation sunset at some, I'm just throwing this date out, December 31st of 2025. And that does a couple things. It gives the school board an opportunity to address overcrowded schools by building a new school, which, well, that sounds unrealistic, but they are building one, and it would affect all of this. And it also gives them, in my mind, a very reasonable time to do whatever redistricting they need to do to get some of the students from overcrowded schools into less crowded schools. Gives them almost 2 years to conclude that process and go through all however they do that, and advise the parents, and then, the town board at December 31st of 25 could revisit, and if you want to vote it for another 2 years or indefinitely or whatever you would want to do, you could do it then. But this way it would sunset, it would effectively, it would go away at that time. And then you could make your own assessment of what to do then, so.
And if I read correctly, the redistricting by the Board of Ed is not even scheduled until 2026, 27.
Well, sometimes schedules change, and even this matter of the carve-outs, I expect some developers they'll be ramping up their pace if they know they're gonna have until July 31st to get something submitted and hopefully, from their standpoint, hopefully approved, so. But those are just, I like the movement from 100 to 110. The abutting, getting rid of the abutting gives the fairness, keeping consistent with the county and their plan is something that would be legally defensible. We're just doing what the Harford County does. And I think that would probably be a move that we could deal with. Obviously, we liked the 110 and the abutting because that's what we recommended and that's what was done. But I
Okay.
understand there's a different environment right now, and your proposal there addresses the issue and still gives gives the town something it can defend, it would seem to be able to defend in court if it needed to. And the carve-outs, yeah, okay, now you don't have victims of this suddenly being thrust upon them. I'm still a little concerned about the July 31st being too soon, but the concept I'm good with.
Well, I certainly appreciate that thoughtful input. The,
It was a rambling thought. I'm
be happy to
70,
answer
almost 4.
any other questions or concerns.
Are we discussing this now, or are we gonna wait until all the public speaks up?
I thought we didn't make, we can stop now if you like. I thought we would question before we ask for a public.
But I certainly have some comments on what Phil just said.
So,
Do you want to go forward with it, or would you rather?
I'd rather wait.
Okay.
if
We'll-
I could, Madam Chair, just, there was one thing you identified there, Mr. Rob, was about, you know, people buying property, you know, with certain zoning and certain expectations. And my overview of the states that have adopted a concept of zoning estoppel, it's never enough just to have an expectation of from any of those high courts in other states that have a more liberal rule in favor of the landowners than we do in Maryland. They do require that material investment moving forward, things like lawyers, drawings, hearings. All of that's a big, big element, even in the states that, and I hadn't seen, myself, I hadn't found any states that said, oh, just the expectation of I bought this, I have an investment expectation, what I would hope to do. Changes could occur, whether it's height restrictions, whether it's how many units, what the setbacks are, all that kind of stuff can happen and change to landowners. So what I'm trying to do here is, you know, put together a salad. Probably makes a lot of people unhappy. Will it make everybody happy? Certainly not. I think that it moves in the right public policy direction based upon, you know, what I found to be the case going door to door in town for the parents. I mean, it was quite an education, you know, of that. And you heard from, you know, like the Girl Scouts, et cetera, and different things. You know, it's a big topic that the public is crying out, and so that's why I'm supporting removing the abutting. July deadline, I'm certainly not wed to that. This is a concept. And when I started really thinking hard about this concept, it was back in December, so it's February 1st. But thank you very much.
Correct me if I'm wrong, Kevin. If a project expires and something changes during the time and they get the extension, they're under the new rules, correct?
Yes.
Okay. So, I mean, I don't have a problem directly with somebody not meeting their time frame and this kicking in. I do kind of have a problem, even though I don't particularly care for the project, with it not expiring and new stuff kicking in prior to expiration. So,
Yeah,
I
I
don't
get
know
that.
whether you want to put, you know, whichever's later, you know, they need a building permit or the date of expiration, whichever's later.
I was putting a sunset with the building permit to be consistent with the Maryland Court of Appeals rulings on the building permit law. And saying, well, instead of it happening when the legislation becomes effective, give them substantial additional time to pull that building permit, is giving them a lot more time than they have under the current judicial
Which-
rulings.
Again,
Yeah.
I'm not familiar with that, so I appreciate.
Yeah,
you looking at
it's,
that.
we're a vested state, and that's what happened even in the litigation when Jeffrey Wilson was president of the Harford County Council, testified in that case. That's one of the opinions of the Court of Appeals, that said, oh, you know what, even though it's a radical change from doing all this stuff, you know, you can change the zoning, and guess what? No landfill in Harford County. That was upheld because they hadn't pulled their building permit and started construction. And the Court of Appeals of Maryland said, we're not going to go with the estoppel analysis of a number of other states. We're sticking to old-fashioned building permit. It's just the risk you take, and the risk is on the developer, and that's where the Court of Appeals has left it. I'm trying to be, you know, say, well, you know, from just a fairness standpoint, from a legislative standpoint, I'm in favor of granting some consideration to that, even though the law would be much harsher. So that's my, and I have no idea, like I said, standing here tonight, whether I have support to get the bill received or passed. But that's why, yeah, that's where I'm really trying to come up with what I think is a good, solid move in the right direction for the students in town, for the schools. I mean, I'm so glad to see I'm so glad to see the elementary school out of the ground, you know, drove by and saw the profile of the school up, and that hopefully will change a
That's a
lot of
big
things
footprint over there.
as well. But,
Once you see it coming up.
so that's honestly where I'm coming from. I don't have any marching orders from any other commissioners.
I
So
just,
that's why the support of this planning commission would be tremendously helpful to me.
a lot of this conversation is above me, but this July 31st deadline, it doesn't stop anything that's in the works, but does it halt future development? Does it affect future development?
No, all that is a carve-out on this law, this APF standard applying. So if the APF standard you no longer consider abutting, that applies across the board.
If you don't have a building permit by November 15th, they're done. It affects for all future developments. So they can submit after November 15th and go through the process, and they will be placed on the conditional approval list with the Department of Planning, and they cannot get building permits.
But
So-
it's only the three that are, everything
Well-
except for the three, they're gonna be affected right away, as soon as the
What-
ordinance passes, right?
Hartford Mall will not be affected at all.
Hartford Mall won't, yeah.
But an XYZ.
And I'm not trying to
I'll give
pick
you a
on anybody,
hypothetical
but I'm just
example,
saying.
Anything in Bel Air Elementary School District and Homestead Wakefield, Red Pump is at 103 right now.
But if, let's just say, here's a hypothetical example.
Sure.
And we passed the ordinance as proposed, as amended. And now I own, which I don't, Thomas and Williams. That's
Mhm.
zoned for multifamily. This ordinance would apply to me right away, wouldn't it?
Yes, it would.
Okay, so in other words, to Pete's question, it's only the three that are spared, given some time.
Yeah.
Everybody else, it applies as soon as it passes, it becomes law.
Okay.
Yeah. So they could move real quick, as fast as they could to get through the system. But if they don't make
Or-
that
or
building
I could
permit
say,
deadline,
well,
they're done.
And Commissioner Rutledge is an attorney and I'm not, and he cited how the law works on that, but I could say, well, I want to make a legal case because you've lowered the value of my property because I can't build apartments there anymore.
Yeah. The only thing I will add to
And
The only thing I would add to Commissioner Rutledge's legal interpretation of the law in Maryland is that vesting occurs when two things happen. Currently in Maryland, where we are, you have to have a valid building permit, and the developer has to have done what is known as quote-unquote substantial construction.
Something more than buy the property.
Correct. So that would mean, generally speaking, and it's fact by facts, case by case. So that generally means footers in the ground. So you could have a building permit, but if you don't act on that building permit and they change the law, you're not vested. So that could change too.
So like across the street, if they don't, not chopping trees down, even though they don't have footers in the ground, they're not doing site preparation to put footers in the ground.
They're not vested right now. Yeah, they're not vested. They still have several things to do.
Would that be affected by the Fair Housing Act then? At that deadline, if there were projects that wanted to come through?
Yeah, it could, because there's, under the original version of the bill and Mr. Rutledge's, there's no end date. There's no end date, there's no sunset, it's based upon a number that is not issued by the town, that the town has no control over, that the developer has no ability to mitigate that loss. So if you've got somebody coming in and they want to provide affordable housing, that is a risk.
That's where that sunsetting the legislation
Correct.
would be helpful legally.
Correct, because what if happens, what if Homestead Wakefield, and again, we're talking hypotheticals. Homestead Wakefield is speculated to be opened by a certain date. Construction delays can happen, materials become shortage, and the next thing you know, it's not open for 2 years.
But even under our current existing process, if somebody wanted to build something, I'm sorry, if somebody wanted to build something and the school capacity was 110%, they couldn't do it.
They can do it.
So, I mean, regardless of whether it's high-priced housing or low-priced housing,
Mhm.
they couldn't do it.
Yeah.
So I mean, the 110% doesn't affect the type of housing that you're building.
No,
And fair
no.
housing shouldn't be involved in that.
Well, fair housing can be invoked if it is a project that is designed for affordable housing, right?
Right, but I
So you
mean,
don't know
it's-
what's gonna come in the door. It could be apartments, it could be,
Right.
you know,
But my point being is the 110% would still stop it.
it would still stop it, yeah.
Yeah.
But
Yeah.
keep in mind that under the existing ordinance, it would have to be not only the school district that we're,
Well, plus the
that
abutment.
project, but all abutting.
Yeah. Yeah. And now, if it keeps going higher, and of course, the commissioners get more complaints, like, hey, I can't build anything. You know, now the entire town shut up because the state rated capacities have gone up. They can, of course, take legislative action, or you can recommend that they take legislative action to lower that to try to equalize that balance again. So you can always do that. The other thing I wanted to point out to you guys, and for the record, all four ordinances, 818, 819, 820, and 821, are all expired. They expired on January 19th, 2024. Mr. Rutledge's proposed amendments came to Kevin and I prior to that expiration, so we kind of put them and formulated them as an amendment to 81823. Even though that says that in your package in the documents, Commissioner Rutledge would have to introduce a whole new, brand new ordinance and restart the process. I mean, so he kind of wanted to catch up, which I think is a great idea to get your recommendations now. So I just wanted to say that for the record, so no one thought his stuff was going to get like fast tracked through. He still has work to do.
No, yeah, and my intent all along was a brand-new bill.
Yes.
And council said because the other one was still technically alive, they wanted to present it to you as an amendment to Chairman Edding's bill. But my
Yeah.
idea was brand-new bill.
Yeah.
And just to confirm to me, this brand-new bill does not have any mitigation for new projects.
No, there's no mitigation that any developer could provide to the town that would try to get them equalize that balance. Like they can't get any relief either. They can't come to the Board of Appeals and say, I can't make the state rated capacity of the school system. They
Other
can't do
than the
anything.
three carve-outs.
I'm sorry.
The three carve-out projects, that's mitigation for them, right? This ordinance would,
Yeah, that would act
Yeah.
as a mitigation for those projects that are in the pipeline. But anything after that November 15th date, they're stuck.
So they're not tied into the November 15th, these three projects?
Yeah.
Yes,
Yeah,
they are.
They are.
Mhm. Yeah.
That's their date. and they
I'm
can
saying
come with
anything that doesn't have a building permit by that November 15th date is stuck.
Yeah, the November 15th date, when we looked at that, as far as what normally the projects run through, that is an ample amount of time to go through the process, get your engineering, get the county to review it, and get an approval for a building permit. I mean, if the final plan has to go from 31st July to 31st August, I'm not sure it really matters, because the final plan, it's just showing that the developer is moving at a pace. One of the problems we've always had in the past is they'll wait around. We used to call it hurry up and wait, you know, I want to get this project. Because what happens is they take that approval from the planning commission and they go to their lender. And then that lender gives them a construction loan. And then that enables them to spend the money, which is a lot more, to have to do all the engineering and architectural drawings that are associated with getting a building permit.
Okay. Thank you. We may ask you to come back and
Certainly.
respond.
Yeah,
Okay.
certainly. Well, thank you very much for the time, your consideration, and your
Thank you.
input. Thank you.
Mr. Goddard?
Wayne Goddard, 128 Northland I'm sorry, 128 North Bond Street, Bel Air, Maryland. Congratulations on being voted the chair.
Oh.
As a volunteer, that means you get a little bit more money than everyone else does, I guess.
Exactly.
Um,
That's why I said
I-
yes.
I have given this an enormous amount of thought as well, because obviously I wake up every morning at about 2 o'clock in the morning wondering if I'm going to get hit for a large amount of money that I made a mistake investing in this town. I think that even with these amendments, it might be good legislation, but now is not the right time. And the reason for it not being the right time is because none of these projects are going to come online until 2026, even if they started tomorrow. So we are sort of giving the school board a pass to not address the situation, and we're speculating that it's something bad's going to happen, and we're speculating and we're conjecting that there's going to be overcrowding. Every person that has come to testify regarding the school overcrowding is talking about a situation that exists right now, like the lady that said her kids were being taught in a closet, and then the little Girl Scouts that said they didn't like to walk out to the trailers. Well, all of those children will have moved through the system by that point in time. So we cannot be in a situation where just to appease a campaign promise that we're enacting legislation that we don't know if it's necessary or not. Although the exemptions are more reasonable, there's a couple exemptions that if this was going to be something that would be considered, and I would be happy to work with Commissioner Rutledge on trying to formulate this. I think that what you do is none of this even starts until January 1st, 2025. I think you give at least 12 months to get the building permit, because I know we're projecting 6 months at least to get the building permit through Harford County, because the problem is we have no ability to speed up the bureaucracy. And there's an enormous amount of opportunity for that process to be slowed down without really any input from the developer. You know, I hate to be nefarious, but you know, if somebody politically connected wanted to make sure a project was going to tank, all you would do is just put the brakes on it and let it die a natural death statutorily. And by the time you get to the permit process, you really have spent millions of dollars. So it would effectively chill all development. But I think if you had to enact something like this, there's an additional carve-outs. For example, none of this applies to the 4-lot or less subdivisions. So I think we need to have an exemption for any project that would be anticipated to generate equal to or less than the projects that don't apply to it. Like, for example, 4 single-family lots, I think using the criteria that was set forth in the comprehensive plan would generate potentially 6 or 7 students. Whereas in my project, with 30 apartments, we're projected to generate maybe 2 or 3 students. So while the project that I'm building is larger in square footage, its impact on the school system is vastly less. So I think that you could create an exemption for projects that are not anticipated to be very impactful on the school. You could also consider allowing the developer to have covenants that age restrict not necessarily the entire building, but a percentage of the building. I think that there's this misconception that developers have no concern or thought for the community in which they develop. And they don't care about the kids, they don't care about the adequate public facilities, they don't care about the sewer, they don't care about the water. That's not the case. You know, maybe I'm not a real estate developer. In fact, I'm probably not. I'm just a business owner trying to bring my business to Harford County, and I need to put some more capacity into the project to make it financially feasible. But I will tell you, I am concerned about school overcrowding. But I don't think passing a quasi-moratorium in 2024, the first month in 2024 or the last month in 2023, is a way to address the impact of something that everyone knew wasn't going to happen for 3 years. And that was my concern about the original ordinance, and I still have concerns. But you know, we were attempting to stop everything. And I was looking at some of the covenants in my loan documents that I have with 19 of my lenders. Every single one of them has a covenant against no moratoriums. So if this legislation is passed, it could potentially breach a number of loan covenants with me not having any ability to mitigate that. And if I breached a loan covenant, then technically the lender could call the loan. And that would result in catastrophic financial failure, foreclosures. You know, I mean, obviously I'm going to the doom and gloom extreme, just like the Girl Scouts did, just like everybody else that talks about their kids being taught in closets and, you know, on stages. But what I think is a reasonable proposal is what we have, what the town is, in my opinion, fortunate enough to have right here, right now, is we have 3 very good projects that are all significantly different. You have Hickory Flats, which is going to have about 80 apartments, which is a completely just an apartment building. You have my project, which primarily is a commercial project with restaurants and a law office and my office that does have some apartment component to it, but not very impactful. And then you have the redevelopment of the mall. I would imagine, because I've been in Harford County for almost 25 years, I would imagine that that's probably the most non-government development that this town has ever seen that is simultaneously occurring at one time. So my thought would be to let's wait to see what that's going to do. And what's nice about the fact that all of this is going to be coming online in 26 and 27 is that also coincides with the semi-annual review of the comprehensive plan. Because if in fact the apocalyptic predictions that my project and Hickory Flats and the mall is going to completely destroy this town, I mean, completely destroy the town. I mean, that's what the commissioners want you to believe, that we are the worst people and we're going to destroy this community. At least we'll have some time to stop that going forward. But let's assume the exact opposite. Let's assume that all of our marketing studies and all of our analysis that we've spent millions of dollars to have performed is accurate. And what we end up having is a very robust town where people walk, people spend money at the shops, people move in the community, they move out of the community. We had this rotational housing where older folks are moving into my apartments and they're moving into the other apartments and they're not burdening the schools. But what they're doing is they're walking up and down the streets and they're shopping at the stores and they're eating at our restaurants and they're going to our churches and they're using our parks. Let's assume that that happens. All of a sudden, we've enacted legislation that is going to make it so no developer in their right mind would ever buy a piece of commercial property in Bel Air because they would realize it has no value. So while I do respect the fact that you're trying to carve out exceptions for my project and other projects, fundamental fairness to our entire community would dictate or would counsel in favor of just pausing. You know, if you enacted this ordinance today, it is going to have no impact whatsoever on the schools. And the voters expect instantaneous impact. You know, we voted you in. I mean, I see it on Facebook. We voted you in. Why aren't you doing this? Why aren't you stopping this? Why aren't you making the schools less crowded? And I think that really what we failed is in educating our citizens of the town of Bel Air and everywhere of how the process works. When we have overcrowding in a school, the process is not to try to put a wall around our school. The process is to try to figure out how to take that excess and distribute it amongst the other schools in our community, which is why the word abutting was included. Because if you simply say, well, we're going to go to 110% and then we get to 110%, well then everyone knows that redistricting is very unpopular. So if you take the word abutting out, all you're doing is helping one set of politicians at the expense of other set of constituents, that being the property owners. Because you all of a sudden give them an easy way to say, well, as soon as you go below 110%, you can start building again. But we can't redistrict you, so we have no escape valve. And we're trying to solve a problem that we might not even know exists. I understand what people say about certain things, but our school system is excellent, and it's going to continue to be excellent. And the reason why our school system is excellent is because we have excellent teachers, we have excellent administrators, and we have excellent families that live in our community. All you have to do is go to any other jurisdiction, for example, Baltimore City. It's not a situation of crowding or funding. It's a situation of, it's a mirror of the community. If we enhance our community in Bel Air, we're going to have a great school system. And I just, again, I'm sort of, rambling here. I guess nobody's timing me, but I just don't think it's necessary. Again, it's a solution that's searching for a problem. And it's one that could, these ordinances could be enacted at any time at all. But I just don't think now is the right time, because there's no problem immediately in front of us that's going to be solved.
Is the application of a sunset date with the proposed ordinance, is that helpful? If we
Yes.
gave-
That's
give-
very helpful, because
give
that,
the schools time, give them most of 2 years to address the problem, and after that, then this would no longer be the law. It would revert back to the
if
current
there
law.
was an inclination to support this, the sunsetting provision would be reasonable. And I think it would be necessary, because what it could do as well is, let's say, for example, I bought a piece of land someplace else in the town. And I knew that there was a 2-year window where the worst-case scenario, I could tell my partners, worst-case scenarios, we'll have to hold this land for 2 years, and then we can reevaluate it. But just doing it indefinitely,
Yeah.
I mean, I can tell you right now, I will never, ever, ever do another development project in this town. Hand to God. I mean, this has been one of the most Kafkaesque experiences of my entire life. I've never felt like such a complete piece of trash the way that these commissioners have made me feel. So my concern is that other people will feel that way. And this will completely shut all the development down. And what you see here is going to be what you get. And, there's going to be no infill development. If the town were to surplus land, it would destroy the value of all the surplus lands, because, there's discussion about possibly, surplusing, the county office building if they moved into the Risteau building. That's a concept that has been discussed. Well, who would buy that? I wouldn't touch that building. I mean, what are you going to put an office there? I mean, it has to be redeveloped. The same thing with, there's a couple other open parcels that could stand to be improved. I mean, nobody is going to be foolish enough to put themselves through this and the torture that is visited upon people who have good motives to do good things, to try to advance good causes.
The
And-
other, the other point that I think I would concur with on you, of the two standards, planning commission approval and building permit, the town, along with the developer, has complete control over the planning commission approval. We have no control over the building permit. So in my mind, I recommend maybe just go to the approval,
The planning commission.
planning commission
Right.
approval, and maybe, it just feels to me like October 31st is a more reasonable date than July 31st.
No, I would agree with you on that, and that's my concern is, I've learned so much about this process, like how enormously political it is. So, I'm trying to navigate this one set of politicians, and then to think that I'd have to navigate another set of politicians down on Main Street to try to shepherd this project through. It's just, it's, to me, there's too much uncertainty. And when you overlay uncertainty with financial risk, that discourages people from taking those risks, because there's no benefit to doing it. The benefit is, you know what, I'll go someplace else where they say what they mean in their comprehensive plans. Like when we did a project in Baltimore City where we converted a dilapidated warehouse that had a tree growing up through it to a brew pub, an office, a gym, and another professional office. We received tax credits. We received a permit liaison that helped shepherd our project through, and we received a citation when we were done. That didn't happen here. Not at all. You know, so we will, developers and business people will skew toward where they're, you know, it's like anything. You'll skew toward where people want the work. You know, capitalism is gonna make it so that there's not any more development because there's many people watching. And one final thought, I was just down in Annapolis about a week ago. I don't know if any of you have been down there to see the governor's housing proposal, but that's targeted at this community. That's targeted at little municipalities trying to discriminate in housing. So, you know, the more we sort of advance these ideas that we're going to try to fiddle around and create these carve-outs so that our existing projects can go forward, but then we're going to shut the door behind them, the more you're going to potentially look as though you're trying to discriminate in housing. And that is a very big concern because if that state ordinance is enacted, all of this municipal ordinance and the Harford County ordinance, all of that's meaningless because in the hierarchy of laws, it's the federal government law, then the state law, then the county law, then the municipal ordinances. So I would just caution, you know, I would almost beg you, you know, the commissioners, the two of you that are here, be mindful of the fact that maybe the best thing to do is to pause, see what's going to happen for a year, because there's not one single one of these apartments that's going to generate a single resident in your town, our town, for at least another year or two. Let's pause and see what we can do there before we sort of go out and try to figure out a solution that has about 6 different exceptions that's going to make it look like it's clearly tailored to benefit people like me or you know, my other people that are developing things. You know, the law should apply to everybody, and they should be thoughtful and they should be reasonable, and they should be intended to solve a problem. Like one of the things that I often see with people who are in politics is they create legislation because they consider themselves to be legislators, rather than just saying, well, here's a solution, let's fix the problem. And will this law that I'm trying to impose, will it fix the problem, or will it make it just appear as though I did something? I think this ordinance, even with the carve-outs, in fact, I think the carve-outs even make it make it more palatable because obviously I'm not affected by it, you know, but it also makes it more inappropriate because it doesn't apply equally to me and everybody else. And, you know, that's what makes it unfair. It's as if to say, well, you have to drive 55 miles an hour unless you drive a really expensive car and then you can go a little faster. And that's the problem that I have with it, is it still is going to be impactful on housing. And I still think that none of these ordinances, which I understand are expired, are going to have the intended consequence or the desired consequence that people think they are. Land is going to be developed. The question is, what will it be developed with? If you basically create laws that make it so families can't move to communities, what does that leave you to build? Thank you.
Thank you, Mr. Goddard.
Couple of comments, just to get an understanding of where myself and staff at the planning come from. We like the revised ordinance that Mr. Rutledge has put forward. And the reason we do is for 2 reasons. One is it's the same as the county. And we look at having a consistency between the town and the county is important. Because if somebody comes in and develops a piece of property in the town where they're allowed to, they're still affecting the class size and the capacity of the school in which county residents' kids attend. Having that consistency between the two is attractive to us, to planning staff. Second is the carve-outs. We think that the ability to have someone come in and expend a lot of money with engineers and architects and whatever else, and then have the rug pulled out from under them is something that we think is unfair. And I think it's something that will probably land the town in court. And that's something that we're concerned about. So I just wanted to let you guys know. Also, just so everybody is understanding of what would happen when, for the if by removing the abutting, what it does is everything that is southeast of Route 1 is in Homestead Wakefield's attendance area. And that would be then put into moratorium for any new projects coming through the door. It also, anything north or northeast of Route 24, with the exception of a couple of locations in where Roland Park or Roland Avenue is, that would also be in the same situation, because those two are in Homestead Wakefield and in Bel Air Elementary School. So those are the two areas that we're talking about. The areas that are in Red Pump are basically the Hartford Mall and the area around that, and then, I don't know what you'd call that, the area where Roland is.
Basically, Red Pump is a county school, Hempstead, Wakefield, and Bel Air.
But it has
are-
attendance areas in the town.
Right.
Yeah, so that's something that, just
But
so
not-
you're aware.
But not as many as the other way around.
No, the majority of the two,
The majority of kids going to school at Homestead, Wakefield, and Bel Air Elementary are Bel Air residents, except for the few that are out there by, what's the place off of Cedar Lane, Cedar Days? in
Homestead Wakefield has a huge attendance area.
Homestead. Well, yeah, but you go back to the golf course and Homestead, but once they put Patterson Mill in, a lot of those kids went there, but
Right.
anybody from Cedar Day, along McPhail Road, and all those guys in the county, they were always in the apartments. They were
Right.
there by ShopRite, by Safeway.
Yeah, I would say 1/3 of Homestead Wakefield is Bel Air kids. And then if you look at Bel Air Elementary, a little bit more than half are Bel Air kids. May even be, maybe like 2/3.
I thought it was a lot more than that.
Yeah,
Because of
I can
where
give
they
you-
go, North Mill Road.
Right. And-
What's the staff and/or council position about two changes, a couple requested changes to Commissioner Rutledge's idea? First, the idea of making it a one-step, this is as applies to the carve-outs, one step as applying to Planning Commission approval, getting rid of the building permit piece, and making that a little more distant date. I suggested October 31st. Is that a legally supportable or? staff's-
October 31st of this year?
Yeah.
For
the
what?
Carve-outs to have Planning Commission approval. Yeah, I think you had proposed, or the ordinance right now proposes July 31st.
Well, it proposes July 31st to have final plan approval.
Final plan approval.
Yeah, because the way it is now is if you have not gone in front of the Board of Appeals or the Planning Commission by December 31st of 2023, you have had to have already been in front of one of those two entities for some kind of approval or review.
But I mean, the next step, though.
The next step,
The next step, you had, if I'm remembering correctly, the next step was a suggested two-piece thing for the carve-outs, that they still had to be in here and get approval July 31st.
2 milestones, yes, July 31st for final plan approval, and November 15th for building permit.
I'm posing the prospect of making the final plan approval instead of July 31st, October 31st, and getting rid of the building permit because we don't control that. I think there was a valid point made, well, if somebody at the county level just decided they just didn't want to have these things done, well, then they could just sit on the building permits.
So
They could.
they would stop, I'm just trying to follow that track. So they would stop in the process there would be no restriction on, if they got the planning commission approval by October 31st,
yeah.
they could get the building permit like a
Whenever.
year later? It,
Subject to our normal rules.
yeah,
here
your
that we
normal
gotta-
rules.
They gotta get it within 2
Gotta,
years.
gotta get within 2 years.
So really, the drop dead date would be planning commission approval as of October 31st, 2024, right?
Yeah,
But no sunset provision, right?
no building permit. I'm sorry.
No
No
final
sunset.
plan or building permit requirement.
No, you're saying
Final plan, not, building permit would be out.
So what's October 31st, what's happening on that date?
Whatever was proposed for July 31st. is that
Final
what-
plan.
that's the
Final
final.
plan.
Okay,
Does that
final
mean
plan.
us, or does that mean you?
Well, typically how the process works, this might help educate folks, is that once it's gone through in front of you and you've indicated an approval and you've issued a letter, and then that letter is countersigned within 60 days. And then by countersigning it, the developer's agreeing to all of your conditions. That's what's holding up Taco Bell and a few other
So it
ones.
means us then, and that's why I just
You
think-
control that, yeah.
I just think July 31st is too tight.
Right, well, let me continue. So you've got approval by the planning commission, you've got a counter signature of that approval, and then you have a final plan. Sometimes what happens is a developer will go in and get all of their engineering done, and that usually takes 6 to 8 months. Usually more like 6. And that, then we have the final plan signature when they have all their approvals for everything else. They don't have to do that. They could come in earlier and get their final plan, as long as they meet all of your conditions. Now, they're in some ways taking a chance, because if they go through the engineering review, say stormwater management, and the county hates what they're proposing, even though the county has seen it several times, because it's a multi-layered process, that could tell them that they have to come back and revise it. But that doesn't happen too often. So what you've got is planning commission approval, counter signature of that approval, final plan, and then building permit. We'll never issue a building permit without a final plan approval.
I guess then I would be looking towards the first of those, the planning commission approval, October 31st.
So that would enable anyone who is right now not submitted to be able to
Talking about
submit.
the carve-outs.
Right, but right now, the carve-outs are that you already had to have been in front of planning commission
We've
or board of
approved 2
appeals.
of the 3 already.
You have, but even the other one, it has been in front of board of appeals, so they qualify for the carve-outs. All 3 do.
Yeah, but in the case of the third one, the Bond Street project, we haven't.
You haven't seen it.
Mm-hmm.
Right.
And as of right now, if I understand the proposed legislation, if we don't see it and approve it by July 31st, then it loses the carve-out status.
You would have to not only have seen it, approved it, but they would have to have revised the plan based on your conditions and submitted a final plan for signature and had it signed. That would have to happen by July 31st.
Yeah, and I'd rather see it be planning commission approval October 31st.
Yeah.
In other words,
That
we're-
does enable people who don't have anything started to start it, but I'm not sure there's anything
But we're talking
out
about the
there.
3 carve-outs
So,
only.
But
on this piece.
understand, planning commission approval means somebody could submit right now
Mhm.
and process through the project.
And we could approve it or not, you know.
Okay, from legal perspective, I mean, that's a little more pliable. What legally I like about Commissioner Rutledge's proposal is that you have less of the possibility of a argument concerning takings, unauthorized moratorium, with those individuals that are currently through the process. So that, of course, makes me breathe a lot easier and sleep better at night. The only thing is that we're still into the la lands of speculation.
So let's, before we keep us in, what's sitting in the pipeline that somebody's said, hey, we're thinking about.
Has there been anybody that's come in and talked to us that has a residential project that they're proposing?
Correct.
We have none.
Okay, so.
The only other
So
thing,
from a carve-out standpoint, we're really not talking about a true carve-out. We're talking about 3 existing projects.
correct,
Two
That-
of which we've approved
Right.
already.
but something could come in tomorrow,
I
you know?
understand
Yeah,
that. Again, that's why I asked the question. Is
Yeah.
there anything in the pipeline
yeah,
that could possibly be affected by what this decision is coming down?
yeah. Now, the only other thing that I would recommend is that the code provides for certain instances where Kevin has administrative authority to submit approvals that should follow in line with their, whatever you decide.
Right.
Remember, we were going through that with his language as far as what approvals we were talking about in the zoning case, and was that,
Right. I mean, we have an instance now where somebody has 3 apartments that have never been,
approved?
were just discovered, and they need to submit and get approval from you because they're apartments and they're in a zone that requires it's a special development. But for the most part, there's not too many administrative reviews that would land in the territory of this restriction.
Yeah, but remember, we could have something in between now and
could.
October 31st. I guess what I'm trying to say is I don't want to limit your ability, whatever restriction, whatever deadline that is, should fall in line with whatever deadline you guys are input. Does that make sense? Like, I don't want it to say planning commission approval and then someone come back and say, wait a minute, I have an administrative approval and that doesn't apply to me because I don't need a planning commission approval. So,
The planning commission approvals that I think we're talking about is just as applies to the 3 carve-outs.
correct, but I'm saying, you know, if you're going to extend it October 31st, I mean, I have to look at it from the perspective of,
Well, we're only talking about the Bond Street project.
No.
because the
Right.
other 2
Now,
are
I think what
approved.
she's talking about is there any unintended consequences?
yes.
There's plenty of potential unintended consequences to do any of this. We talked about that with a hypothetical property that
Right.
happens to be R2, and now I'm not in the carve-out, and I feel like I'm disenfranchised. And both of Commissioner Rutledge and Liz have, at least to my satisfaction, well, if they haven't done something so
Yeah.
far, then you're probably on safe legal ground.
Yeah, anything that
Correct.
that involves a new dwelling unit, I cannot approve. It has to come in front of you.
yeah. I just didn't want to hamstring you, Kevin, and because that definition makes a difference. If we say planning commission approval and we don't say administrative review
We're
and
only talking
something,
about the carve-outs.
yeah.
3.
I understand, but I'm looking prospectively at what could happen, and we just don't know about it.
Well, and that could, you forgetting about the carve-outs, if the legislation passes, certainly somebody could come in and say, well, I thought I could build this thing that I haven't submitted anything about, and I'd like to do it, and now you're telling me I can, and you're letting Bond Street go ahead and the other 2 that you already approved.
Yeah, but they're going to stop as of October 31st if you're pushing that date out, right?
The October 31st would really only apply to Bond Street. That's their carve-out date, that the law doesn't apply to
Then,
them.
yeah, it would also apply to Hickory Flats.
Hickory Flats is already approved by this panel, and as is Hartford Mall.
So you're going with planning commission approval?
Yeah,
Okay, okay.
that
But-
would be my thought,
But if we,
as applies to the carve-outs.
but if we approve this motion, we're still creating a moratorium, are we not?
Yes, as it relates to those areas of the town that increase the state rated capacity at 110. There's no relief and there's no end in sight until the Board of Ed decides to
why-
do it.
That's
So
why I'm
there's no
suggesting
sunset provision and
There's no sunset provision.
mitigation for
sunset
any
Correct.
new,
the ordinance.
Well, one-
I
no
said
mitigation for
12/31/25.
new projects.
One thing that I might just add here, and I'll let Mr. Rutledge, because you've been patient. The date or the time that Homestead Wakefield is likely to be finished. Likely is a big word.
Speculative.
Yeah, very speculative. Is 2026, 2027. It's probably going to be more 2027. That is almost guaranteed to relieve capacity issues with Homestead Wakefield. And if Board of Ed takes action, which there is no guarantee that'll happen, but they could certainly redistrict between Homestead Wakefield and Bel Air Elementary. That can't be that controversial, but
You think?
I'm supposing. So that, finishing that up does certainly address everything, and I think that is, to me, if I'm looking at something, that would, a sunset would be more appropriate in 2027. Because then if they don't take action, then you're allowing you're allowing the developers to proceed at that point. I'll let you.
I'm completely in favor of changing the fourth prong from July 31st to October 31st. And I think, a sunset date, I have no objection to building that into legislation that I propose. I would want to just make sort of a background comment from what I've read in the background materials about these APF standards across the state. There are a number of jurisdictions that are right at 100%. Those are the ones that provide for a builder out. The ones that are like 110%, I'm not so sure they specifically provide a builder out. A lot of those jurisdictions, though, do have the ability to enter into the development, so what's the acronym?
It's a developer's rights and responsibilities
Right.
agreement, or DRRA.
And
That
that
was
is
another
something that I
suggestion.
understand that our code could probably benefit. It's not really the topic of tonight's discussion, but would benefit by some enabling legislation that would allow that. I don't think we have enabling legislation in place to be able to pursue those currently. Is that correct?
That is correct. So the commissioners would need to adopt enabling legislation, which basically is just adopting the letter for letter provisions of the land use article with respect to that. Now, if you provided some mitigation at even 110 where you're stuck, that might help. So one of the options that I had suggested that hasn't really been investigated that I'm aware of is going to the board and saying, how about we get some sort of a fund started, and the town of Bel Air would hold the funds, the developers would pay into the funds, and those funds would be turned over to the Board of Ed when they identified a project for a town of Bel Air school that needed construction, renovation, or something of that nature. And that could be like utilized in a DRRA.
I was just thinking that, I just want to take the opportunity to bring that up. I saw that was in the memorandum that you had shared with the Planning Commission, just because I think that that's something I'm definitely interested in studying further and trying to move forward with and propose to the commissioners and come back and consult with you all on, just because apart from the APF, that kind of tool in the tool chest can help out a great deal on whatever changes or regulatory changes are afoot. And before I'm seated, I just wanted to mention that I did spend 10 years in South Georgia as a civil rights attorney fighting racism, suing the school board down there for still not obeying Brown versus Board of Education in early 1990 in many aspects. And so I've dedicated my legal career to the defense of constitutional rights and civil rights. And I would hope that my concern for the Maryland Constitution, which after the Civil War passed a specific provision that said it is a Maryland constitutional right to an education. That's part of the Maryland Constitution. So my proposal here really is based on that constitutional right, which is clearly being weighed against other constitutional and civil rights. But I have no racial animus whatsoever at all. I have fought against it tooth and nail to great sacrifice to me and my family personally. I'm grateful to be able to be back in my home county, Harford County, and Bel Air, and finish raising my children here. It was a tough road to hoe down there. It was, I just wanted to share that with you all, that I'm all about opportunity for everybody. And thank you for that.
What about when you take into consideration, though, that the redistricting is going to be finished in 2027?
It may not be.
You-
The school
no
may-
guarantee.
The school may be done, but it could be redistricted in 2028 or 2029.
And you also don't know how attendance changes, but they have predictions or projections throughout 3 years. So it should be relatively predictable, but
Let's ask that question. So what big county projects that can affect Bel Air is going to happen in?
what big county projects? I don't know of any
Because-
county
Because
projects.
that, I mean, we're talking about, you know, the square miles of Bel Air, but we're not talking about the excess capacity outside.
Oh, so you're talking about projects that are
So-
occurring in the county
Right.
that might
That
affect
will
town
Correct.
schools?
The reason I like the particular proposed legislation to sunset December 31 of 26, isn't to do with when the new school opens or doesn't open on time or delayed. It's two things. It is, in any of this issue about are we acting against fair housing, well, this thing's gonna sunset. It's gonna go away. And the other piece is, in my mind, it gives the Board of Education plenty of time between now and December 31st of 26. We're talking almost 2 full years to do whatever redistricting it needs to do
3 years.
to get the schools less crowded.
It's a lot more palatable to be able to go into court if there's a lawsuit filed and say,
That's what I'm
look,
saying.
by the time you get to it,
Yeah.
this is going to be over with. And they're going to be like, why do I care?
And I say when that date comes and goes,
Yeah.
there'll be, new facts will be known about how impactful any or all of this is gonna be, and the town board can take any action it deems appropriate
Mhm.
at that time. They can extend the same law for another indefinitely or for another 2 years, or just let it go away quietly. It gives them all the latitude that they can need. But I don't think we should be held hostage to a date of, well, the school may be a little later opening or not opening, and let them, they can, if they're overcrowded, they've got some tools that they can use too.
So your recommendation would be to make that July date October 31st and then
I've got the, for the carve-outs, October 31st of 2024.
I'm sorry,
For
21st.
final plan.
For final
October-
plan- For
You want our
planning
approval.
commission approval.
Planning Commission
Okay.
approval.
Is that what you had,
Yeah, so just so we're clear, I think this language, the way that staff wrote it, saying final site development plan or subdivision plan approval regarding the zoning case is granted no later than, and we would say October 31, because that takes in whatever else needed to be done for the final approval. There could be some things that the planning commission said and the checklist that has to be done before the final approval.
yeah. You're adding 3 months for the final plan, or if you're talking about planning commission, you are allowing new development to
Well,
put his foot in the
No,
door.
That's only gonna be the carve-outs that this applies
Theoretically, new
to.
development doesn't happen because
Well-
nobody did anything.
The rest of
before
the
December
legislation.
Yeah, right.
Mr. Rutledge's legislation only really applies to the three. If it's October 31st, planning commission approval, I don't know what's out there. There could
Yeah.
be new stuff coming in.
Well, could I interrupt there for a moment?
Go ahead.
So I don't think that that's really the concern from my perspective, because criteria one is, well, criteria two is they would have had to have a public hearing on their project at least prior to December 31 of 2023.
Right, which isolates the.
Right. So I'm fine with the October 31 on I was just didn't want to get caught up in the bill in case there was another step that the director makes before it's technically final, because planning commission approval is gonna you know, but if, however, that's a technical aspect that I'm not, it's above my pay grade. The concept, though, that you're proposing, Mr. Rob, I have no problem with that. That July 31st may be too tight from a practical standpoint. October 31, and having, I would, you know, be willing to put that into my bill, and I would also be very much willing to put in the sunset date of December 31 of 2026. The concept, you make a good point about the building permit not being in anybody's control here, and I hate to concede the point that, you know, there could be gamesmanship potentially. Something never really crossed my mind as I was making this up, because I wasn't tuned into the fact that that building permit process is something that Director Small can't, you know, really make sure happens if somebody's qualified for it, and not just stick it in the door somewhere. That's just
Right,
be
the way,
shameful.
just for people viewing it at home, the town relies on the county, Hartford County, to review all of our technical plans. So that includes architectural plans, it includes stormwater management, sediment erosion control, and several others, electrical, blah, blah, blah. So all of those are done by the county. I would hope that, I cannot imagine that those plans could be held up for what would end up to be 8 months. That's, you know, 8 or 9 months. That's, I think we would have a problem with that.
How would you solve the problem? How would you solve the problem?
Well,
That's the thing, is the gamesmanship. How do you solve the problem?
one,
How do we go down to county before?
I hear your question, and the question, the answer is the entity that issues the building permit is the town of Bel Air. And if they slow walk this to the point where it becomes an issue, that's something that certainly we can write in, but we can still issue a building permit if we're satisfied with the plans that are provided. Now, we don't like to do that because we want to get an approval from the planning commission first. Or not planning commission, the county first. But
But generally speaking, Kevin, they've already provided comments by that point in time, generally, right?
generally speaking, it takes around a 6 months process to run things. And they also have a development navigator position now with the Office of Economic Development that is supposed to help that process through.
Yeah.
What's the downside to eliminating the building permit from the equation at all? What's the downside? What do we, if we're...
You know,
we're looking for these
I'm not
carve-outs,
sure
we're
there
looking
is
for
a
them to minimum
downside just
time.
because,
From my perspective, there's no downside.
yeah, because
why I don't know why
your
See nothing wrong with
approval
it.
would still be in effect and,
Yeah,
uh,
you can't have anything new come in until it sunsets. If it's
so
extended
that
or,
would be the 2 years after planning commission approval.
yes,
Or their expiration.
or there, well,
Well, that's the expiration date, 2
Yeah.
years.
Well, no,
Well,
the law sunsets in 2 years, but they
Oh,
have different.
I'm sorry, I'm getting the
regulations.
two confused.
yeah, so again, if they
Mall
hit
have been
that
approved and they'll have
point,
their
then they're
own
gonna go into the queue, and then they're gonna have to hold up if they don't get
Right.
built. But the building permit almost like fixes that. If you'll remove the building permit because they have 2 years, it sunsets in 26, if not extended, or the state rated capacity drops below the 110, right? They still have that option, the three carve-outs can still move forward.
First of 24, 25, 26. Any project that has to have planning commission approval by October 31st would have 2 years, so it would be October 31st of 26.
So then they would
So
just
they
come
would
back to the PC
expire.
and ask for an extension.
They would have to come back and ask for an extension.
But
If
HIPAA
the,
expires
January.
January
From now.
next year.
before then, yeah.
Right, so they would have,
they could apply for an
right,
extension
Yeah,
because they're in the carve-out.
I can't see any problem with that. I just,
Can I jump in here? I'm getting so frustrated by this whole discussion. This, everything about the carve-out and the exceptions and all that, this is all a red herring. The real question is whether the removal of the abutting language makes sense. And to me, it does not. I don't think that there is any significant population cluster in Harford County that is as divided among various schools as the town of Bel Air is. We have, what, 3 elementary schools? At least 3.
I think we have 5 elementary schools.
All right, 5 elementary schools. We have 3 middle schools, and if I'm correct, 3 high schools.
Yeah.
In the small area that constitutes Bel Air, and yet we're going to try to divide Bel Air into these little segments dealing with just one school each when we take out the abutting language. And to me, that's farcical. That was put in there for a reason, and the reason was because Bel Air is so divided among the different school districts. We can't control what the Board of Education does with its boundary lines or its attendance levels. And by taking out the whole abutting language, we are dumping our problems into the Harford County Public School System because we can't control what they do. We absolutely lose control over any outcome in the town of Bel Air, and we have no idea how it's going to affect development down the road. And on this, I will echo what Mr. Goddard said about who in their right mind would come into Bel Air for development. I have already advised a client not to buy property in Bel Air, given the current climate. I could not assure him that he would be able to do the project that he wanted to do. And it was a perfectly sensible, logical project that was consistent with other uses in the town of Bel Air, but because of the current climate, I couldn't tell him, oh, absolutely buy, because you'll be able to get your variance, you'll be able to get your zoning exception. So they're gonna look for something in the county. That's gonna happen more and more. This is just nonsensical, what this is doing. Said my piece.
Yeah, well, I mean, I think earlier this evening, I said, well, we obviously preferred the structure as it now exists because that's what we recommended to the town board and they approved at that time. And now we have a different town board with a different view of all this, and we have a proposal that is somewhere between where it started on November 20th and where we were with the last comprehensive plan, that's all. And now, do we want to find some common ground there, or?
Well, but the
Obviously,
point
we
is,
we just do our
I don't
advisory
want to
here.
be complicit if the town board decides to change the rules. We've all seen it, those of us who have been on the planning commission for more than a few years know that when the town board wants to, it says, well, we passed this because the planning commission recommended it. I don't want to be put in the position of recommending something that I find is fundamentally flawed. I will vote against this change.
About an hour and a half in, do we have a motion?
do you guys, and I'm just asking to sort of wrap it up, to cover our bases, Kevin, do you guys find that this proposal, either 818 as originally proposed or Mr. Rutledge's amendment, is consistent with 2022 comprehensive plan? Do you guys think that? Because you guys are bound by that plan.
No, I don't. Do you want us each to answer? Is that what you're asking?
Sounds like yes. I couldn't quite hear you.
Well, in keeping what Keith said, all right, based on the abutting school zones, all right? So there, I don't have this in front of me, so let me just borrow. So the abutting school zones are Hickory, Red Pump, and Prospect Mill. Now, you want to say what you want to say, but I don't consider Hickory or Prospect Mills abutting schools to the town of Bel Air. Red Pump, yeah, kind of, but even that still draws, you know, a ton more people out of the county than it does the town of Bel Air.
Mhm.
The two schools, Bel Air Elementary at 111% and Homestead Wakefield at 115, I consider those abutting school districts within the town of Bel Air. The current legislation, changing it from abutting or non-abutting, still none of these projects could be built. The only reason why Hartford Mall says it could be built is because of Red Pump. They're going to push all those kids to Red Pump, and they won't affect the school districts in Bel Air. But you know as well as I do that that's the current thing, that we have no clue of what the Board of Ed will do 2 years, 3 years, or even 5 years down the road once the projects are done. I mean, I'm kind of inclined with Keith saying that they shouldn't be, but.
So basically, you guys are of the opinion that it's not consistent with the
Well,
comprehensive
I
plan?
don't think it is, because,
Okay,
again, but at the same time, I don't see Hickory Elementary or Prospect Mill as abutting to Bel Air,
okay,
so.
okay,
And I feel the same way.
okay. Because,
Talking about high schools or elementary schools?
Elementary
Elementary.
schools.
There's a whole bunch of other elementary schools in the area.
Well, you have Hickory, you got Ring Factory, you have Emerton, you have Singer, you have, you know, down 24, but what we're showing here is quote-unquote abutting, are those two schools.
Right, and when you're referring to abutting, the language is that they are abutting that attendance area, so that the Board of Ed has the opportunity to redistrict and balance the capacities between a district that's below
They
capacity.
could send a.
So it's not Bel Air, it's the attendance areas for Bel Air Elementary, or, okay.
It accommodated the theory that they could, if they chose to, if Bel Air Elementary was overcrowded, they could send those kids to Hickory. That's what,
Or Prospect Mill.
that's where it's meaningful
Right.
for.
They just
Hickory to
changed
be
the lines.
An abutting school.
Yeah.
I just wanted to make it clear, so, you know, when Kevin goes back and drafts his commentary, your written recommendations to the Board of Town Commissioners, that we cover that base for each one of them, because, you know, that's really your guiding light, is that comprehensive plan. And if you don't, that's fine. If you do, that's fine too. Whatever works, so.
So how would you like us to proceed?
Well, I think at the minimum, we need a motion for the revised ordinance.
Well, I'll move it. Might as well, we need to get a recommendation one way or the other here. So, move it with the dates that were discussed.
Can I clarify that? Just so,
October 31st, and the whole thing, this
So
is
that-
to do with the carve-outs.
So-
so that the item number 4, under the ordinance language, that final site development plan or subdivision plan approval regarding the zoning case is granted no later than October 31st, 2024.
So is this a motion to recommend it?
I'm
Am
just
I
wanting to
misunderstanding?
clarify, I'm trying to clarify exactly what.
I
you
know,
wanna
so you're
propose.
recommending that it be that it pass with these amendments, or are you saying, as a board, no, I don't want it recommended, but if you're gonna do it, then do this? I'm just trying to understand what,
That would really be my view. I'm obviously, we're in
Does-
favor of what we had already, but if there's gonna be changes, I would prefer these changes
okay,
than what was proposed November 20th.
okay.
Doesn't this have to be introduced at the town board level before we make a recommendation on it?
No,
No.
No?
Mm.
no, in fact, most of the time it's not. Most of the time, it starts here.
He brings it to you.
My motion will be, we like the school adequate facility the way it is now, but if it's gonna be changed, we recommend Commissioner Rutledge's proposal with these adjustments of dates that he's concurred with in conversation at least.
And those adjustments are the sunset on December 31st, 2026, and final plan October 31st, 2024.
Yep.
So you need a
Okay.
second for recommending approval.
I'll second it to move it along.
Okay, Phil Robb,
I will vote aye.
Don.
I can answer to Paul.
Okay, okay. Don,
As much as I'd like to move it, I kind of listen to what Keith's got to say, and it makes a lot of sense there, so I'll vote no.
Keith,
No.
Peter Schler?
No.
Chair votes no as well.
Motion fails.
Okay, so the.
Do you
if
want to
that-
make a
if that motion,
motion
yeah, do we have to,
to not approve?
exactly, that's what we would need.
So we would need a motion to recommend not approval of Commissioner Rutledge's amended 81823
And the original.
and the original.
I'll make a motion that we do not approve the amended motion or the original motion.
Second.
Phil,
No.
Don,
Yes.
Keith,
Yes.
Peter.
Yes.
Chair votes yes as well.
Thank you.
All right.
Thank you.
Okay,
Now we're going to go on to to just discuss, if you remember, we
right, this would
chaired-
not have, unless you disagree, this would not have public comment. I need to know.
We've done that twice.
Huh?
We've already listened.
The
to-
next three that we're looking at, we've already had public comment, so I just need to,
And
Is
these
it-
all three have expired and have not been reintroduced. in
Right.
Some other form, okay.
okay.
And why are we commenting on that they've expired?
The reason being is because if the Board of Town Commissioners decides, and it's possible, to receive your recommendations and then reintroduce them, incorporating your recommendations, suggestions, and comments, that might be helpful to them.
It's up to you. If you, I think it would be a good idea for you to let the town board know what your opinion is on these items.
I agree.
Okay.
All right, the fee and lieu for open space. Proposed legislation would prohibit the allowance of a payment in lieu of provision of required open space. Relatively straightforward when it comes to that. You have a lot of lists of municipalities there that some allow fee and lieu, some do not. Havre de Grace does not allow it, but they also don't require open space for most of their development. Aberdeen does not allow fee and lieu for open space. Harford County does allow fee and lieu, and the way that's calculated is 110% of the cost of the raw land, or off-site improvements that both the developer and the county agree. Mount Airy allows fee and lieu. Laurel allows it. Easton allows fee and lieu for PUDs only. Frederick does not allow fee and lieu. And Westminster allows fee and lieu for planned unit developments and high-density residential. Basically, this is a developer assist. I would not call it an exaction. It allows a developer the flexibility if they do not have the practical ability to provide open space on site, that they can pay a fee for that. One of the things that's not in the town regulations, but it has happened in the past, is to do improvements on county or on town land or parks. Let's see. Over the years, the town of Bel Air strengthens its open space requirements by including area and width minimums. So the open space would be, right now is required to be 10 foot wide and has to have a 500 square foot minimum. That's not shared anywhere else in the county or the other municipalities. Active open space is limited to exterior applications such as ball fields, play courts, playgrounds, whatnot. Doesn't have to be grass. It can be a tennis court. Potential interior applications such as fitness rooms and gathering spaces are not specifically addressed, although these have been permitted in the past. In addition, there is no specific allowance for a developer to provide off-site improvements, nearby local park, whatnot. And phasing the implementation of open space is permitted in 55 and over housing, but is not allowed anywhere else. That's why when you looked at Legacy at Gateway, that they phased in the open space. their requirements were phased in. Fee and lieu allowance is a provision shared, again, with the county, and I already went over that. Some of the options here, and these are the ones that I'd like to explore if you want. Allowing fee and lieu to remain as it's currently applied, that's one option. You can recommend that. If permitting of a fee to replace the provision of open space is not desired, flexibility on how the open space amenity can be provided is appropriate by applying one or more of the following selected changes. Use the county requirement of 110% of the assessed area of raw land, and for raw land to be the standard for the fee and lieu calculation for both active and passive open space. One of the things that right now our requirement is $50,000 an acre. If Hartford Mall wanted to do this using the county's calculation, it would be 10 times that. It would be, this is Hartford Mall. What's the cost of raw land in that location? It'd be extensive. Allow all developments to offer phased implementation of open space. This would need to be bonded. This is something that could happen at the mall. So there's an allowance here where they showed you a open space calculation or an image. They could bond that open space, and then they would have to implement it at some point within a certain number of years. Provision of off-site open space, active or passive, with the planning commission approval, and that allows the developer to go to a local park, trail, public amenity. Both the developer and the town would need to agree to that in writing. You can't require it of them. They would have to agree. Allow for a wider variety of amenities that are interior to a development, such as fitness rooms, indoor courts, community rooms that can be limited to only active. Revise the definition of open space to allow for smaller areas of land to count as open space. One of the reasons why we wanted the larger areas, the 500 square feet or the 10-foot wide, we didn't want people counting landscape islands in the middle of a parking lot as open space. That's something that we just don't feel is appropriate. But you could still allow it, and it's allowed in other places. Exempt B2 district zoning from open space requirements. This, I'm a little, I don't know. I'm not sure I like this, because what it's saying is if you're residential, your development doesn't need to require the amenities that developments, 5 minutes down the road do. To me, they all should have to provide something. So I think the B2 could be the one that provides the open space, whereas some of the others may not. If you're in B3, do you really need it? You're in much larger areas. R3, things like that. Those could all be removed, and you keep the B2 or similar as something that allows for fee and lieu. That's our options, or you can just say, no, let's keep it the way it is.
I'm inclined not to get rid of fee and lieu. I think it's allowed us to do projects in town that may not have happened, and, so that's just my thoughts.
I agree, and not only that, but I think it's served us well for our parks, and it's not hard to visualize future projects where having the fee and lieu of option would allow a redevelopment of certain areas right here in the center of town, in the absence of which would preclude them.
You were about to say something.
I was just going to say, legally speaking, fee and lieu is a concession that the town has given to developers since 1990. There is no issue one way or another. It's not a constitutional right. I don't have a takings, I don't have anything. If a property cannot provide the required open space pursuant to the code, they have the option to seek a variance from the Board of Appeals. So they have an option. The only other thing I would just add to Mr. Small's recommendation is number 2, his second recommendation. absolutely nothing wrong with that. I would just point out that the recommendation would constitute an exaction under Maryland law, which is prohibited unless it's in writing. So that is kind of where the DRRA, Developers' Rights and Responsibilities Agreement kind of discussion might also come into fruition. So nothing wrong with his recommendation. I just wanted to point that out because an exaction off-site, that would be a no-go under Maryland law as long as we had it in writing. And again, we're just kind of circling back around to the development rights and responsibilities agreements. I think I put it in my letter to you, but I just want to clarify with DRRAs, if you guys ever consider that, making that recommendation, that is basically a trade-off. So we talked while Commissioner Rutledge was at the podium about vesting and Maryland law and when it says it and what it means. Under a DRRA, for the developer to get a set date, as in the date of that agreement, under a DRRA, they give up an exaction. It could be off-site, sewer improvements, water improvements, open space, a park, whatever. There's all kinds of options and ideas that you could use. But it solidifies the date for the developer. You are vested as of this date. You got to comply within a certain period of time. The agreement will expire within 5 years. So I just wanted to point that out as a thought process. So.
What was the fee in lieu of the Harvard Mall? It was 70? 175,000.
176.5.
I mean, that's a
I know that
significant
number.
amount of money. And, you know, it's going to go to good use, and I kind of like to keep this going.
Just to clarify something, this is not something that a developer has a right to. We have to approve.
Yes.
They have to apply for it, and we have to approve it as well.
The way the current code is not only do you have to approve it based on impractical ability, but also the town board has to approve it.
But I just want to make sure it's optional. It's not something that they have
No.
a right to.
Yeah,
And
you're
if-
right.
If you took it away from our ability to approve it with a finding of fact and then send it to the town board, that would be one path. The other path would be Board of Appeals, and what would they have as a standard?
It would be a variance, uniqueness of the property.
Could they just make it arbitrarily or based on, in other words, when we do them, when we recommend them for approval, it's with a finding of fact as to why?
Correct.
Is there a comparable standard for the Board of Appeals, or
It-
would they just say, well, we're either for it or we're against it?
No, they are on a clear and convincing evidence standard, which is more than preponderance of the evidence, but less than beyond a reasonable doubt. And they have to show that the property is unique, and that uniqueness creates a impractical hardship. So your burden or your standard is a lot lower and easier for them to satisfy than the Board of Appeals.
And if we, under the existing rules, if we recommend it with a finding of facts, and if the town board says we disagree, we're not approving it, then the petitioner would still have the right to go to the Board of Appeals?
That's correct.
Okay. Well, that sounds like a pretty good system to me.
So is everybody in agreement with the $50,000 an acre? Or do you want to base it on land value, like the county does?
I like it the way we have it right now.
Kevin, do you know, just out of total curiosity, I never found this in the legislative research I was doing. Do you know when that 50,000 per acre went into effect?
I think that was around 2000.
Because land
14.
values have probably
It should
gone
be
up.
indexed to
It was part of the
inflation.
fee schedule when it was
Okay.
changed, so it was around 2014, 15, might have been later.
Okay.
I have no
Okay.
problem indexing it.
Having it
Indexed
indexed
to
on,
We need a consumer price index inflation rate there.
it's definitely a gift. I mean, there's.
Oh, it
and
is.
when I'm looking at that amount, we're being generous.
Well, you said, you referred to the fact that it would be 10 times more if it was in Harford County. Well, maybe we should have some kind of an inflation adjustment to what we have, seriously.
You could do that.
We're not getting gifts, so we should,
Yeah.
we should be getting gifts.
We can get lease on it.
All right.
Presumably, the numbers should be an amount which encourages the developer to have open space on the site, but not so prohibitive that if they can't do that,
Right.
then they can't do the development at all.
Well, I will say that I do like the idea of doing a phased approach as part of this, because if somebody knows that they're going to eventually provide the open space, and there's and it's phased in, and it has to, and there's a bond associated with that runs out, say, in 5 years, then it has to happen. Or they end up getting punished with fee in lieu. I like the idea that it should not be encouraged to do fee in lieu. This is something that should be the last resort. And sometimes these guys come through and that's where they go day one. And sometimes it's because they don't have any other options, which our code is vague in that. Not having phasing and not allowing specifically to go off-site and do something elsewhere in the town.
The example I always think of here would be Maine and Churchville. If the county in its wisdom ever decided to dispose of that and get it into private ownership for development, then it's hard to imagine there being a realistic parkland, open space piece of that. So I would say there's a case where it's not practical, and let them pay, and I'd say let them pay more. If the 50,000 was the right number in 2014, it isn't anymore. So we should.
I will say that there's one piece of land that I wish we would have had the ability to go purchase, and that would have been the one that is where you enter the rhododendron. It's outside of our corporate limits, but it would have made lots of sense and the land went for relatively cheap. I think it was $165, and it should have been purchased. I think the county should have done it, but I think had the town had the money, that would have been a perfect. And then
You're talking about where the annexation didn't happen?
where the annexation did not happen,
I
yes.
couldn't even get that town board to annex it, let alone buy it. I mean,
But I'm just giving that as an example. Something comes through where you're looking at that going, gosh, it's right next to a park. It would expand the park. Just having that money available to do that would be, I think would work. Or if you have some kind of developer exaction that says, go purchase that property,
And deed it to me.
And deed it to me, yeah.
Didn't happen, now there's a nice home on it.
Right.
so.
So is there any thoughts about, right now phasing is limited. Would there be any thoughts about allowing phasing to be expanded
Well,
to?
what's in front of us right now is a proposal to get rid of fee in lieu of, right? That's all we're acting
Yes.
on tonight.
Well, you could,
But we could,
you have flexibility to do whatever you want.
Sure,
'cause that's
yeah, you can make
expired.
whatever recommendations you want.
You don't have to. I'm just,
Yeah.
Well,
well, where would you start? What figure? I mean, how? What?
I wouldn't. I'll make a motion that we recommend to the town board that the proposed changes to the fee in lieu not be adopted, and that they encourage the staff to develop a proposal for a phased-in, or not a phased-in, but a stepped assessment based upon value of the land, or
Okay.
square footage, or however.
I would second that.
Okay. Phil?
Aye.
Don?
Aye.
Keith?
Aye.
Peter?
Aye.
Chair votes aye as well.
all right. Next one is reduction of building height. This is really limited to the B2, B2A, B3, and B3A. And I can go through those if you need to, but it's in your package. Current maximum building heights in the Bel Air vary. All residential zoning and districts in Bel Air keep proposed building heights at 40 feet or below. The current proposal is to reduce the maximum building heights in the B2, B2A, B3, and B3A districts to 40 feet. And it has a couple of ramifications. One is that in the B2 and B3A, your setbacks vary on building height. So if everything's reduced down to 40 feet, you don't need those setbacks anymore. So that would go away, and that's in the legislation. Town has height exceptions for churches, hospitals, schools, libraries, places of public assembly where the height limit may be exceeded with the additional setback, and it's at a 3-to-1 ratio. So if you can go 3 feet above the height limit as long as you set back 1 more foot for your setback, and then it just keeps on going up. Havre de Grace has quite a few, ones that go way above 40 feet. Residential, institutional, in certain instances, 60 feet, multifamily, 80 feet. Aberdeen building heights range from 40 to 60 to 80. 60-foot limit is applicable in most cases and most business districts. Harford County limits building height based on the number of stories, not feet. 3 stories is the limit throughout the county, with the exception of the R3 and R4 districts, which allow apartments in the county. B3 which allow, I didn't finish that out, which allow a greater amount. Berlin, we looked at some of these other ones. Berlin is 2.5 to 3 stories. Laurel is 2.5 to 3 stories, except for in business zones. Mount Airy is 3 stories or 40 feet, except for industrial zones. Westminster is 2.5 stories, except for business and industrial zones. So see the pattern here? Exception for business or industrial. Most building height exceptions are typical for all jurisdictions, so you have exceptions. Elevator towers, parapet walls, HVAC units, cooling towers, holding tanks, all of those are exceptions to building height. And that's no real different than most other jurisdictions. There are several developments in town that could be made non-conforming. I don't know. We estimate there's 4 or 5 that would meet that. I don't know whether they do, because we would have to get the money to go out and survey those. It also kind of creates problems with topography. A lot of developments will do what they typically is called a walkout condition, where you have 3 stories in the front and 4 in the back. That would probably be affected and create a nonconformity. Although it's one of those that we just don't know until we actually survey those. Current code requires the building setback from right-of-way in the B3 districts and the B2 districts. When proposed structure exceeds 45 feet, that goes away. Imposition of a building height limit of 40 feet across all districts may encourage divestments in certain zones, and the ones we had kind of identified as the B2 and B3 districts. If you're in B2, your property values are higher. You have limited ability to expand because there's all the lots are small. And the same thing with the B3. It's just land values are high. Let's say uses such as 55 and older residents always will need an elevator if you're 55 and older, and that serves a target demographic that cost of those elevators typically necessitates more units and additional height. This application would benefit from additional height, again, for mixed use, because mixed-use buildings will typically have office and or retail on the first floor and residence above. The application, again, would need that critical mass to support diverse mixes of uses. Highway commercial areas located, again, near Baltimore Pike would benefit from the additional floors. And one of the big things there is you're not near residential. It's not like you're creating an impact. You're not relieving someone of an impact. But it is a look that I think a lot of people were saying we don't want to turn into Towson. That is I think that's probably where that came from. Expansion of the setback in the B2 and B3A from 10 feet to 25 feet appears to be designed to mitigate impact on abutting residential districts. This requirement conflicts with the typical 10-foot setback this would create nonconformities all over the place. Now, they may not be something that ends up being effective, but you have a lot of parking lots that are a lot closer to adjacent residences than 25 feet. This requirement also create numerous non-conforming developments and unintended consequences for even minor development. Limited availability for developable land, higher costs associated with the acquisition of development and development have resulted in pressure to build more square footage and higher buildings. The more something is valued, more land, the more property is valued at a higher rate, the more a developer has to put on that property in order to make back their investment. That's kind of what we're getting at. But the desire for lower building heights is consistent with the comp plan to retain the small town feel of Bel Air. These two competing forces need to be addressed in the code while not preventing future opportunities for growth and not affecting the ability for affordable housing. Some options are limitation. The limitation proposed appears to be an attempt to attenuate the impact of larger and taller structures, require additional setback ratio of 1-to-1 based on the height of the building. So if you have a property that's right next to a residential and it goes 10 feet above the building height limit of 40 feet, it needs 10 more feet of setback. So higher the building, the larger the setback from residential.
So how, I mean, this isn't anything new. I mean, we had the same issue with that one property that was considering, 4 stories on Main Street that never happened because they were gonna stair step it back.
Yes, and then the stair stepping was done because that setback that is currently required in the code took effect. So that's how they avoided that.
Right.
Yeah. Another option is retain the building height limit of 45 feet in the gateway zoning districts of B2A and B3A without allowing for higher buildings in those zones. Since these are located, again, near residential, they're gateway districts. That's hence the name. And they're designed to offer a transition from more intense commercial uses. Another option is adjust the building height limits in the B2 and B3 zones to allow for additional 10 feet, making it 55, to compensate for the investment and the upfront costs. This will allow 55 and older and mixed-use residential developments to address the inherent necessity of elevator structural needs, flexibility, things like that. It doesn't do a whole lot of change to the existing code except for B3 would go from 65 down to 55. Remove the 25-foot buffer amendment to keep the 10-foot requirement and suggest that the additional landscape buffering be provided and/or fencing, walls, things like that. I think what we're looking at is, I think you can have that small town feel in these transition zones of B2A and B3A. It's just how you do that. Because the B3 and B2 don't really need the transition. They're not, there are some that are right next to residential, but most of them aren't.
I know it's water under the dam at this point, but looking at the Hartford Mall project, would they have a setback of what, 25 feet? Like on
yeah.
Bolton Street?
Yeah,
So that's what we asked for, or that's what we have in here?
that's what the code has.
But as we as a planning commission, could we have said, based on the amount of acreage that you have, again, I get into the whole thing about taking and stuff like that, but could we say, we want another 10 feet back from Bolton, and you can spread out this way?
You could.
Okay, I just wanted to know whether we could have.
Yeah,
done
you
that.
just have to provide reasons for doing that.
Right, well, I mean,
Yeah.
if, when you say you don't wanna look like Towson, if you go to Towson, you look, everything's like right up to the curb.
Yes.
And right up to the sidewalk, or maybe has like 5 or 10 feet. So if you push it further back, then, because, again, let's face it, the mall is a special animal in the sense that it's got plenty of property.
Right.
So, but that was just curious
Yeah, and yet,
whether we could.
it's
we
not
could have
that
asked
long ago, we had a school of thought, and I believe Carol Dybel was one of the advancers of this, that we would benefit in some situations of having stuff up on the sidewalks.
Exactly.
Especially when we talked about Route 1. That would,
Exactly.
and when you think about it, boy, that would be a much more aesthetically pleasant thoroughfare there if the businesses, just take Truist Bank. And that was one of them in particular that she tried to nudge them to put the building up at the front and have the parking behind. Oh, it'll look like we don't have any parking.
Well,
And
I
so they
mean,
didn't do it.
I remember that, and also remember, we, you know, past the building there, coming out 22, past where Garces got, you know, now, and that got right up to the curb, but, you know, when something's up to the curb, then if you need to put another lane in, you're never gonna get that.
And,
So, I mean,
That
well,
would be good.
well, I get it, but.
well, Raising Cane's,
Well,
We want less
ba-
lanes.
based on the amount of traffic that comes through, sometimes
When-
an extra lane might be good. But my point being is, there's a give and take on stuff like that. Just because you wanna make it look structurally linear, you know, sometimes if you have extra space, you have the ability
This
to do stuff in
creates-
the future.
Raising Cane's showed their building where it was because we made them do that.
Yeah, I know.
Now, one of the things that I do, I mean, I think there's again, ability to compromise here. You can have the 40-foot limit and not have any setbacks. And then say, okay, if you want to go above 40, you have to have that additional setback. And that might be something where you have that ratio of 1 to 1. Up to you guys.
My only, excuse me, my only concern is that, excuse me, this is the same balancing act that we did years ago when we changed the
Yes.
height way back when. And we went through this whole small town versus, you know, tall buildings that developers need, because if you're gonna put in an elevator, you need a bigger footprint, or if you're gonna have a mixed-use facility, you know, or if you're gonna provide parking, whatever. We've already gone through this balancing act, and now we're being asked to rebalance it all with the same arguments being used. I just don't see the need.
We gave it to them, and they still couldn't make money, so.
I don't disagree. No, that's-
I know that most of the time, up until about a year ago, it never was an issue. Because nobody came in and wanted something that was above 45. I think the highest building that we had, I would say a year and a half ago. The real issue was the academy. But they were existing. That was already an existing building that was there. Everything else kind of fit. But what happens is that I think that the town and county were reeling from 2008 and the economic downturn, and it took a while before the developers came back into town and started looking. And
Well-
right now, you're looking at Maryland that has a woefully short fall in residential, in dwellings, about 90,000 across the state. Makes homes much more expensive and much more attractive to build.
The land in town is too scarce and too valuable to go horizontal. It needs to go vertical. We've kicked that around for the last couple of
Well,
comprehensive
there's-
plans.
Just in town, there is land.
You have to go up.
horizontal.
And the example I used at one of our previous meetings was my longtime place of employment, Hartford Mutual. If that was an empty lot right now, and the company said, oh, we'd like to build that exact building that we have there now on that site, they couldn't do it with this, right?
Based on a,
Cursory look.
cursory look.
And I think that would be a mistake. I think that's a great building, and I think one like that would be ideal, so.
And I kind of thought that in reading this, that it was really targeting apartments. And again, that kind of leads me to the Fair Housing Act, and just
Right.
sounding like broken record on that Fair Housing Act, but that's the way I read it.
Yeah, and the comprehensive plan is the way you guys did it, designed it, was that it was supposed to promote sort of mixed-use apartments and affordable housing. So, you know, you guys have to make that decision, but is it consistent with the comprehensive plan?
I
So-
move we recommend against ordinance 820, expired ordinance 820-23, based on issues with the potential litigation with fair housing law and with the non-conforming uses that would be created by such legislation.
Second.
Keith?
Aye.
Peter?
Aye.
Phil?
Aye.
Don?
Aye.
Chair votes aye as well.
Okay. Last one. Reduce the number of units per floor and per building block. Amendments to the code propose to limit the number of dwelling units per floor to 4 for multifamily uses. This proposed revision also includes a restriction to the number of stories to no more than 3, which would mean 12 dwelling units per building block. This amendment also allows the Planning Commission to increase the number of dwelling units to 6 or a total of 18 per that building block based on specific criteria. Density limit in the current code for multifamily is 20 units per acre. The Havre de Grace uses one definition for apartments and has no limit on building height. And they do have limits in the zones, but not as particular to multifamily. Both Aberdeen and the county have 3 definitions: garden apartment, mid-rise apartment, and high-rise apartment. Garden apartment is a minimum of, I do stress the word minimum of 4 dwelling units and no maximum. Mid-rise is 8 dwelling units, no maximum, and high-rise is also 8, no maximum. The stories are garden apartments limited to 3 stories, mid-rise 4 to 5, and high-rise 6 or more. Berlin allows no more than 12 dwelling units. Westminster limits multifamily to 25 units per acre. Laurel is very vague. I couldn't figure out how they did theirs. It ties it to the comprehensive plan. Frederick limits based on density, which varies per zone. Easton limits multifamily to 16 dwelling units per acre. Elkton is 14 dwelling units per acre. Again, there are some apartment developments in Bel Air that the capacities are greater, some of them are less. It just kind of depends. So some of them would be rendered as non-conforming. Let's see. So, but there are also several developments in town that are 4 per floor and are typically limited to 3 stories. So you've got those 12-unit developments. And you just drive around town, you can kind of tell.
When were they constructed?
Most of the ones that are 4 per floor and are 12 dwelling units per building are more recent.
Oh, really?
Yeah. Now, what they'll do is they'll take those that are 4 per floor and 3 stories, and they'll sometimes marry them together. So you have 8 per floor, 3 stories. So it kind of depends. I don't know why. I suppose that's just a way of being efficient with your land. Let's see. I'm going to go straight to the recommendations. Proposed changes desire to reduce the density of multifamily and to break up the architectural and site design of proposed developments. That's by limiting per floor. That's how it breaks it up. The result may impact the availability and price of multifamily units. The prices will go up. These changes appear to be unsupported by code in other jurisdictions. Almost nowhere do we have these kind of regulations that we could find. Some of the options are attenuate the impact of density limits on multifamily. Viable option might be to create and define two separate categories for multifamily uses, similar to Hartford County and Aberdeen. So the town could take our single definition of multifamily and create two. Garden multifamily, which would be 3 stories, 4 units per floor, and 6 units with PC approval. That is consistent with what's already been proposed. And then mid-rise could be 4 to 5 stories, 8 units per floor, and 12 units with PC approval. Now, what we would propose to do is have only the gardens approvable in the B2A, B3A, R3, RO, B1. Those are the less dense zoning districts. And then in the B2 and the B3, you allow these to become greater and to go to 4 to 5 stories. And again, those are places where you're not next to single-family residential or townhomes. So the ability to get more dense doesn't necessarily affect the neighboring properties.
They'd still be tied to 45 feet.
Well, yeah, so this proposal and the previous one somewhat conflict, depending on where everything lands. So we had to kind of make a recommendation, but yeah, you're exactly right.
So let's just say the developer sees how well Hartford Mall does, and they recognize that nobody's gone into the old Dick's thing, and they decide that the parking lot in the Dick's store makes sense to make a multi-use apartment complex there. And just, because they're what, like B2 over there? Or B3?
Where Dick's is right now?
Yeah.
Has
No,
moved?
no,
The old Dick's. Oh, they're B3.
B3. So they could do a mid-rise.
Yeah,
Right.
using these supposed standards, they could do mid-rise there. One of the things that we've tried in the past to push is to allow residential, especially 55 and older, to go in some of these shopping centers. And the reason we've kind of pushed that is if you go to Columbia, every one of their village centers has a grocery store, inline shops, and one mid-rise residential. And that's instant customers, and it's parking sharing. When and sometimes those are 55 and older, sometimes not, but what it does is it creates this activity, for most of the time, and you can parking share. So when residences are out and gone away, you've got the retail and commercial and office utilize those parking spaces, and when they come home, those are, so the peak hours are not shared. It also, again, creates this ability for, it's like a,
That's not COVID or
typically a lot of those,
It's not even cold.
typically a lot of the uses that are going there are convenience uses. They're the dry cleaner, the stuff that those people in the residences will use. So that's why we're trying to do that. It's just being efficient with the amount of parking that you're providing.
That would be the hope for the mall if they ever could get the grocery store occupied.
Well, that's the concept. Now, one of the things that they did, which I don't really like, is they're putting all their parking internal to their building and not sharing it. So they couldn't share it. That's something I necessarily, but they were making it structural parking, and having structural parking does allow them to at least get a building height bonus, but not much else. Yeah. So, if that was made 40 feet, they could get a building height bonus of another 5 feet. So, let's see. Also, with just a couple of housekeeping things, is moving a standard that relates to townhouses to the same section that this is being proposed at, and including a definition of building block. So. You guys are worn out?
Is it fair to say that this final expired proposal does subject the town potentially to fair housing violations, and that it also creates non-conforming uses.
Yes, there is a concern with fair housing, because again, we are singling out multifamily uses.
Based on those two factors, I would recommend against 821-23.
Second.
Okay, Phil,
Aye.
Don,
Aye is against.
I guess, no, I understand that. So we're completely eliminating any sort of aspect of the ordinance, but yet some of these kind of make some sense. So we,
And you could certainly amend our
no, I'm just
motion to,
I'm just wondering whether or not we should look at eliminating the offensive parts and looking at this to say, hey, what about a couple of these?
Certainly, I mean, you have the ability to recommend whatever you'd like to the town board.
Now, for the time being, we'll say that,
Okay.
or yes.
Yes to the motion.
Keith,
Aye.
Peter,
Aye.
chair votes aye as well.
All right.
do you want to make another motion
Well, I
to
mean, I
support
just-
aspects of it? I mean, that's,
I would make a motion that, you know, to, for the town board to consider at least items number 1 and 2. I guess all of them, 1 through 5. In their next, in the next time they come up with.
Am I correct in thinking that if those type of amendments were adopted, that the Hartford Mall project would not have been approvable?
If the amendments as currently proposed,
No, the amendments that the staff outlined, what we could do.
I think they would still have to revise their architecture, but it would be doable.
But how is it that they qualify as the 8-unit per floor?
Well, that's why they would have to revise. They would have to create, right now, they have this big kind of U-shaped building. They would have to break that building up into individual buildings that would meet that 8 per floor.
Which is incompatible with their theory of having, you know, a single lobby that services the entire building. They would
Yes.
have to radically redraw the whole project.
Yes, I mean,
Scratch it, just don't look at it.
okay,
I agree with what Keith's doing. I mean, the whole concept of the habit trail is a lot more
okay,
convincing than a bunch of different buildings on site.
right. I think one of the
Especially
things that I had a little bit of heartache with is the building out at the Hartford Mall, it looks a little too monolithic for me. And it would be nice to break it up. But I do understand what they're talking about, is that they have a single lobby, and that lobby reaches out to all of the different portions of that multifamily development.
Okay, is the motion and
Yeah.
second still standing?
Right, so,
we voted.
I thought
you can, it can die
voted.
without
Oh,
a,
that we did.
No, nobody.
yeah, it can die without a second.
Okay, sorry, sorry.
All right, does anybody want to talk about existing projects, or are we headed home?
I have one thing. Can we talk to the post office or whoever owns the post office and is running it to the post office of repainting the arrows in the lot? Because nobody seems to be able to understand that the arrows going this way, that's the way you need to go.
Okay,
They're going out through the entrance and they just need to be freshened up,
Is
so.
it the arrows or the drivers?
Ah,
I just
You
don't
know,
think,
the-
I think the drivers just choose
They
to
don't
ignore
care,
it.
they don't
They
care,
just
but
choose to ignore
at
it.
least make me feel better that they can say, hey, I didn't see it.
There are
All right.
also potholes in the Hartford Mall, and you've got to go around
Well,
some
that's private-
substantial
that's private
sizes.
roads over there. The
Yeah,
interesting pothole experience just to interject, this was Friday night. Of course, it was, the ice and snow had just melted and potholes exploded. And I was up at the fire pit at the Independent Brewery. We're sitting out there sipping our beer and listening as cars went by northbound, hitting a pothole, and you could hear the tires flattening.
Oh, it's a
Well, they
nasty,
went- It was quickly repaired on, I think, Monday. It was
yeah.
fixed.
Yeah,
but
I
it
think
was-
our guys got on it relatively quick on our roads. The state roads, I think, came a little later.
Yeah. You
What's
could- you could-
happening
you could
with the
sit there and
pile
listen
of
to 'em.
rubble next to Klein's?
The what?
The pile of rubble next to Klein's.
You had to bring that up, didn't you? They had applied for a demolition permit. It was still under review, but due to, problems on their end, their contractor thought that they were good to go. They weren't. So they demoed the house. We found out that morning and issued a stop work order probably around noon. But it was too late. I mean, you demo a house, it goes quick. They're now kind of going around trying to figure out, they have to get all the remaining approvals that they need to get, which should happen relatively quick, and then we'll probably issue the permit at some point.
So how
But
many
yeah.
permits are they asking for in that area?
Just that,
Just that one?
Yeah.
That's number one.
yeah.
How about the Brown, on the side, on the Gordon Street side, the Brown extension?
Not that I know of, I don't believe that they, oh, you were talking about that, yes. That was an extension that they did, and that just went through an administrative review because it wasn't enough of a expansion of square footage to require your review.
I didn't know whether that was part of what they're doing or
I think it's instead of,
instead of.
yeah. Of course, I'm trying to get them to take that away after they put the other side on. I doubt they'll do that.
Did the county buy Brown Young's building?
Yes,
So we lost tax revenue.
yes.
How much tax revenue did we lose?
We've lost, potentially, the town could lose a sizable amount of tax revenue. Not only because of that, but also because of property that was purchased or may be purchased. I don't know, Mr. Goddard probably knows better than I do. The old M&T Bank building and associated parking lot. Also, the state is in the process of purchasing property off of Marketplace Drive, ostensibly to move district court, but that'll be years from now. I hope it never happens.
They'll have to have two
No,
offices.
no.
Furious. I mean, the consensus with the bar is that work belongs in downtown Bel Air.
You don't want to take your life in your hands walking there?
No. They love being able to go right across the street.
Sure. Before we adjourn, I'd just like to say thank you for having the confidence in me to continue, and I could not do this without the
Oh,
four
sure
of
you
you. No, I couldn't.
That decision would be made at the state level, right? The state controls that decision.
Yeah.
All right, thank you.